Welcome to my channel, Clark the Realtor. Don't forget to subscribe and let's get started.
What's going on, guys? Welcome back to the channel. My name is Devon, or Clark the Realtor. Thank you for joining the channel. Today we are going to talk about an act that has just been passed in the state of Georgia called the Safe at Home Act. It has come into effect July 1st, 2024, and this is in response to tenant and landlord relationships. So let's jump into a little bit. If you are a current tenant or renting from a complex apartment or a single family house, this might go well for you. Don't forget to like and subscribe to the channel, hit that notification bell whenever videos drop, and let's get into this topic, y'all. Here we go. All right, guys. So as mentioned, a new act has been put in place, or you can say a new law. It's House Bill 404. Anyway, it says Georgia Safe at Home Act establishes landlord minimum requirements. So they are establishing a minimum requirement when it comes to landlords providing tenants with habitability and also safety and health issues inside of that rental property. All right, it says in March 2024, HB House Bill 404, also known as Georgia Safe at Home Act, was passed by Georgia lawmakers establishing minimum requirements for landlords and property owners to provide rental housing that is safe, healthy, and free of risk. It says Safe at Home Act strengthens tenant protection. Prior to the Safe at Home Act, Georgia was one of the few states that did not mandate habitability, meaning landlords were not required to maintain their properties in a condition suitable for human habitation. It says tenants facing unhealthy or unsafe or unhealthy living conditions also would have had access to limit legal. The Safe at Home Act aims to change this dynamic by strengthening tenant protections, clarifying landlord responsibilities, and ensuring a fairer renter market. So I kind of digged a little bit into this bill, and we will go through it as well a little bit. So it not only protects as far as the habitability of the tenant when it comes to landlord relationship, but it also protects the landlord in a situation as well when it comes to people being holdover tenants. So holdover tenant is someone who basically had a legal lease at this place. The lease ran out, they stopped paying, and they've been slowly kind of almost squatting or holding over in this particular, whether it be a single family house that they're renting, a condo, an apartment, they're kind of sitting there. So it kind of had, the bill also has that included inside of it as well. It says right here, minimum habitability standards. The act ensures a duty of habitability, requiring landlords to maintain properties in condition fit for human occupancy. This includes functional plumbing, electrical systems, heating, cooling, freedom from hazards like pest infestations, mold, and leaking roofs. Landlords should take proactive measures to ensure their properties meet these standards. Regular maintenance checks, addressing repair requests promptly, and adhering to local building codes will minimize potential issues. So that's another thing. They're going to have to hit those building codes. And I noticed, as far as helping people get into rental properties down in this Metro Atlanta market, that a lot of my clients will call me, even though I'm just a realtor and I can't really help, but I always try to do my best to reach out to the company that they're renting from, or or any type of person that we were in contact with as far as when they were getting into this rental, to just have a conversation and make sure they're connected with my client. But a lot of landlords down here, because of these companies, they have management companies, they're not fully connected with their properties. They kind of shifted over to a management company. The management company, they're just managing the property, and they always say they're managing the property for the purpose of the landlord and not the tenant, so they don't care about the tenant. And this is now going to kind of address this issue where you're going to have to care about these tenants now. These tenants are paying a lot of money, especially in the metropolitan area of Atlanta nowadays in 2024, even though rents have kind of sloped a little bit down. However, they're still expensive comparable to different parts of of the states. So a lot of people, I always say this to people, when they flock down to the metropolitan area of Atlanta, they think it's so much cheaper from where they're coming from. And then they realize real quick that it's expensive to live down here compared to the income in which you make, and then also the pricing of the rentals, or even if you're buying a house, it's very expensive. So you have to understand the market, talk to a local realtor, do more research, and understand what's going on. So security deposit limits. Security deposits are now capped at 2 months worth of rent, down from any previous amount a landlord might have imposed. While this reduces upfront costs for tenants, it reinforces the importance of proper tenant screening and clear lease agreements outlining expectations for damage beyond normal wear and tear. So in regards to security deposits, I'm not really sure about this. I've never saw, I guess I've seen it as far as clients that might have not the best credit might be required to put down more as far as payment when it moves into apartments. I've never seen 3 times the amount, so then that they kept it at 2 months, which is great. 2 months as far as security deposit, which is great. I've never seen them go that far up, but I could be wrong. The eviction process right here, it says landlords must now provide written notice to tenants before filing for eviction. So the state that I come from, I'm not initially from this Georgia state. The other state I come from up north, they were always required as a landlord to have a written notice as far as eviction for tenants. They do it down here in Georgia to some extent, where they give you an eviction. They'll give you like I know some of these apartment complexes, they'll give you, if you don't pay your rent on time, you'll get a certain amount of days for a late notice, and then you'll get a certain amount of days as far as they'll tell you if you don't pay this late notice, they're filing for eviction. And it kind of works different with single family homes, but now it's going to be a requirement outlining the reason for eviction. So they have to outline why they are evicting you. It says tenants are also granted a 3-day grace period before eviction proceedings can begin. So they're giving you a 3-day grace period where you, before that eviction process will begin, which allows for clear communication and adherence to the eviction process can help avoid unnecessary disputes and legal complications. So basically saying this can help the tenants and the landlords not have to go to court, pay for all these fees and do all this stuff, where we can kind of just move people out smoothly without getting to that process. I'm not a lawyer, so seek a lawyer when it comes to this tenant eviction process, because this will be more around like legalities, lawyers and stuff. I can talk about like the security deposits and the habitability stuff, but I'm not a lawyer. All of this will require, if you were to say like your apartment was uninhabitable or things were going on, I would reach out to the building code people, the inspectors over at housing, the housing authority, different things like that as far as building codes, because they will remedy some of this habitability stuff. It depends on what state you're in, what city you're in, what county you're in, because everybody moves according to their own process. It's crazy nowadays. Implications for landlords. The Safe at Home Act helps landlords by defining minimum habitable conditions, reducing ambiguity and potential disputes with tenants regarding state of the rental property. All right, it says by proactively maintaining the property and addressing issues promptly, landlords can minimize the chance of facing potential lawsuits over any uninhabitable conditions. Additionally, well-maintained properties can lead to properties that increase in value over the long term. Okay, y'all, let's dive a little bit into the bill. A bill to be entitled an act to amend Chapter 7 of Title 44 relating to landlord and tenants, so as to provide for a duty for habitability for certain rental agreements, to provide an exception to such duty, to provide an exception to landlord for liability, to provide for definitions, to provide for notice, to provide for a maximum security deposit amount, to provide for expedited evictions for certain criminal activity, to provide for a short title, to provide for applicability, to provide for related matters, to repeal conflicting laws, and for other purposes. It says this act shall be known and be cited as the Safe at Home Act. All right, let's jump into some of these. Right, it says in any contract, lease, license, agreement, or similar agreement, or oral or written for use of rental or real property as a dwelling place, a landlord or a tenant may not waive, assign, transfer, or otherwise avoid any other rights, duties, or remedies contained in the following provisions of law. Code section 44.713 relating to the duties of a landlord as to repairs and improvements. Code section 44.714 relating to liability of a landlord failure to repair. Ordinances adopted. Article 3 of this chapter relating to proceedings against tenant holdover. Article 44 of this chapter relating to distress warrants. Article 2 of this chapter relating to security deposits, and then any applicable provision of Chapter 11 of Title 9, which has not been superseded by this chapter. So this right here is Section 3. It says relating to landlord's duties as repairs and improvements as follow. It says except as provided in subsection B of this code section, the landlord shall keep the premises in repair and shall be liable for all substantial improvements placed upon the premises by such landlord's consent. It says any contract, lease, license, or similar agreement or oral blah. So this kind of states the same thing we read above. Section 4, said chapter is further amended by revising code section 44.714 relating to the liability of the landlord. Again, you guys want to talk to a lawyer to understand more of this bill in depth. I am not a lawyer. I am just giving you what they are stating as far as putting in place. says, having fully parted with possession, the right of possession, landlord shall not be responsible to third persons for damages resulting from the negligence or illegal use of the premises by the tenant, provided, however, the landlord shall be responsible for damages arising from defective construction or damages arising from failure to keep the premises in repair. So this is basically saying, what I'm kind of interpreting out of this, again, talk to a lawyer, is that if you repair it as the third person, the third party, it's not the landlord's. I mean, if you destroy it or you damage it, it's not the landlord's fault. They don't have to fix said things that you damaged. However, it says, however, the landlord shall be responsible for damages arising from defective construction or for damages arising from failure to keep the premises in repair. So if let's just say you're in your apartment or you're in your house and the HVAC goes out, you didn't cause it to go out. It just went out because it's either bad, the motor stopped working, different things as far as your furnace or whatever, and it goes out because it's old, it's defective, then that landlord is responsible to getting that repaired and getting that fixed in order for you to have sufficient cooling or heating in the house during those summer and winter months. So this is kind of how I'm interpreting this part of the bill. Again, talk to a lawyer to let them interpret it further, because I might be wrong. I don't know. That's how I'm interpreting it. Section 5 is further amended by revising section code section 44 of code section 44.714, landlord's duties as utilities as follow: as used in this code section, the term utilities meaning cooling, heat, light, water, and service. So they're talking about making sure that's sufficient. Right here in section 6 is talking about no landlord shall demand or receive security deposit in the amount exceeding 3 months, which we already talked about earlier. And then this last part right here, section 7, is in regards to relating to the demand for possession upon a tenant's refusal, concurrent issuance of federal lease, termination notice as follows. It says, in all cases when a tenant holds possession of lands or tenements over and beyond the term for which they were rented or leased, such tenant, which we talked about earlier, which is called a holdover. So they had a lease in place prior. The lease has expired, or they're no longer under a lease, but they failed to continue to pay. They're considered like a holdover tenant, and the landlord has right to, as they're saying right here, or has engaged in criminal activity as defined in subsection. It says, in all cases when lands or tenements are held and occupied by any tenant at will or sufferance, whether under contract or rent or not, when the owner of such lands or tenements desires possession of lands or tenements, such owner may individually or by an agent, attorney at law, or attorney in fact demand the possession of the property so rented, leased, held, or occupied. If the tenant refuses or fails to deliver possession so demanded, the owner or the agent, attorney at law, or attorney in fact of such owner may immediately go before the judge of the superior court, the judge of the state court, or the clerk or deputy clerk of either court, or the judge or the clerk of or deputy clerk of any other court with jurisdiction over the subject matter, or a magistrate in the district where the land lies, and make an affidavit under oath to the facts. Such affidavit may likewise be made before a notary public. It says, if issued by a public housing authority, the demand for possession required by subsection A or C of this code section may be provided concurrently with the federally required notice of lease termination in separate writing. So it's basically saying that they have to, like I stated earlier, have to give you notice as far as that eviction. However, they have the right to evict you as well. So it's saying they can go in front of the court, they can make an affidavit under oath of the facts that they know, and they can legally evict you. Why wouldn't they evict you? You guys are sitting in the property in which they own, and you're not paying for said property. So you're living for free. You're basically squatting at this point. I want to thank you guys for coming to my channel. My name is Devon Clark the Realtor. If you're looking to buy, sell, again, you can reach out to me at dclarktherealtor@gmail.com. Have a wonderful day. Don't forget to subscribe, like, and share the channel. Hit that notification bell when new videos get uploaded to the channel, and I'll talk to you soon. Bye-bye.
Thanks for watching. Don't forget to subscribe.